Thank you. Good morning, 8 o'clock. Can everybody hear me? John Baker, you will be my sound test, okay? 8 o'clock sessions, I don't know whose idea this was. It certainly wasn't mine or Lynette Boyle's, but in order to kind of get everybody up to speed and without getting you up to do jumping jacks, I usually like to begin with kind of a humorous story. And as many of you know, Neil Armstrong, the astronaut, died this past week, and there's a kind of a funny, famous story that has been circulated about him, and some of you may know this. But apparently after he made his famous statement when he was on the moon, one small step for a man, one giant leap for mankind, and he was talking to the command people, just before he got back into the moon lander, he was heard to have said, "Good luck, Mr. Gorski." Well, for years and years, NASA was trying to find out who Mr. Gorski was, and they assumed it was a Soviet cosmonaut who Armstrong was competing with. And he was asked several times, what did he mean when he said, "Good luck, Mr. Gorski"? Well, 26 years later, in an interview, he finally agreed to explain it. And he said, "I feel I can talk about this now because Mr. Gorski passed away within the last year." And he said, "The Gorskis were our neighbors." And he said, "When I was a small boy, my brother and I were playing baseball. My brother hit a fly ball into the Gorskis' backyard. I ran over to catch it. It was a hot summer night." And he said, "The windows were open on the upstairs bedroom of the Gorski home, and I could hear Mrs. Gorski saying, 'Sex? You want to know when you're going to have sex with me? I'll tell you when. When the boy next door walks on the moon, that's when.'" All right. So if we have time, I have a couple more stories. But this is about agreements for post-adoptive contact and communication, and if I can work this right, get through it. Everybody knows what relinquishment of parental rights means. It effectively terminates all legal status and relationship with the parents. The real key to the relinquishment, at least for a child in HHS custody, is that the relinquishment must be accepted in writing by the department. Otherwise, it's not legally effective. The relinquishment ends all obligations of the parent to support, provide for the child. It basically is the legal termination of the relationship between parent and child. So what parental rights go away? You guys know this like the back of your hand, but it's the right to care for the child, have custody, the right to even establish a familial relationship with the child, the right to enjoy the companionship of the child, and the right to visit with the child. In certain situations, though, even after adoption, Nebraska makes it possible for a parent who's relinquished parental rights to continue to have visits and/or communication after that adoption. How? Okay. By the way, I'm a very strong believer in a principle called death by PowerPoint. We sit with these same backgrounds, so I tried to spice this up a little bit since it was 8 in the morning. How? LB 531 was passed a long time ago, and the legislative statement here is pretty clear that the reason is to encourage and facilitate the adoption of children who are in the custody of the Department of Health and Human Services. LB 531, the big thing here is it allows the biological parent to relinquish their parental rights with the knowledge that they can continue or may continue contact and communication should both the bio parent and the prospective adoptive parent agree that this communication is in the best interest of the child. And how much visitation or how much contact is basically up to the parties to agree to. For those of you coming in right now, there are handouts in the back that go with this presentation, so hopefully there are enough. There should be like 4 of them. Nebraska has these statutes. They're very important and they're included in the handout. They're 43-162 through 165. These authorize the creation of a written agreement between the bio parent and the prospective adoptive parent, and it can be for the continued contact and communication. The agreement is not absolute, though. It is subject to approval by the adoption court. And there's some little glitches in that statute that I'd like to fix, and we can maybe talk about those if you have questions. Right now, it talks about the adoption court and modification or changes in a different court, and that makes no sense. It should all come back to the same court. You don't use this agreement in every case, obviously. You know, we have some toxic parent problems. We have some situations where it would not be in the child's best interest. So every time a parent relinquishes parental rights, you're not going to be, you may consider this, but it's probably not going to happen in the majority of your cases. When would you use it? First, it presumes the parent and child have established a positive relationship, and there would be some kind of finding that continued contact and communication would be in the child's best interest. Now, if you're like me, you're sitting there and going, oh gosh, if those things are there, why is the parent relinquishing parental rights? Sometimes, I had a client like this, a parent has a very good relationship with her son, but she had a mental illness, and she really just couldn't sustain the day-to-day demands of parenting. At a supervised visitation, she was able to make him hot dogs and macaroni and all those kinds of things, but beyond that, if the visit went too long, she could not put up with the stress of it. She couldn't redirect him, and she just couldn't handle him, but she loved him dearly, and he knew her as well. You might consider using it where you have a parent of an older child or teenager, where preserving that communication or contact is regarded as important to the child's best interest. We've all had those cases, at least the attorneys here. I know you've had the cases where you think this parent's rights should be terminated tomorrow because they're so terrible in whatever way, but the child is 13 or 14 and really has a well-established bond with the child, and the parent, again, is able to circumscribe their unfitness pieces and relates fairly well. And the department very often, or NFC, or whoever it will be, will make a recommendation that it's not in the child's best interest to terminate parental rights, not because you're helping the parent, but because you don't want to do further damage to the child who already thinks that relationship is important. Where a sibling of the adopted child resides with the biological parent, this is really unusual, but it can happen that a parent somehow has or retains custody of one child and the other, and is relinquishing to the other child, and that may be for behavioral reasons, medical reasons, that the parent cannot care for that child. But if you have some kind of a sibling connection that's been somewhat established, this would be a proper factual basis to at least start thinking about, would an open adoption, I don't like that phrase, but would a contract for continued contact and communication, which is harder to say, would that be appropriate in this particular case? Okay, don't use the agreement. Can anybody think of some times you wouldn't want to use the agreement? Okay, too early for interactive?
When a parent might want to start their relationship that they didn't have in the past, but they've now been clean and sober for a week, and so now.
Excellent. Right. One basis, and that's by statute, is it's not proper to use these agreements to get to know or become acquainted with the child. They don't say it that way, but I think where they say where there's no prior relationship established. Anybody else think of a factual reason why you would not want to use this kind of agreement? So, speak up.
When you're doing that so that you get the relinquishment.
Yeah, that's a kind of a legal reason. When you're inducing the parent, right, to come on, give up your parental rights, and we'll let you have some visits, and then you slam the door, kind of thing. All right. Let's see. All right, as a means of getting to know the child, under 43-163 subsection 2, it's very specific that you do not. This is not proper. If this child is, say, 4 months old and the parents never met the child, you don't set this up and say, gosh, I can now get to know my child. It presumes a previously established relationship. Did somebody over here have a comment? Who's calling me? Okay. Where the parent's relationship with the child has been abusive, and that can be any number of levels: physical, sexual, psychological, emotional, or the parent's behavior has been toxic or disruptive to the child. This is probably not a very good idea to have continuing contact and communication. Again, I'm not giving you a watertight rule. There may be that situation where a parent who really is unfit can regulate behavior appropriately for the limited purposes of a visitation, and probably the visitation would be much more tightly restricted. And maybe there wouldn't be visitation at all. Maybe it would just be telephone calls, letters, that kind of thing. Another time you might not want to use this is where the parent is unlikely to live by the agreement. If you have a history of a no-show parent or periodic disappearance, We've all had the cases, the parent does good for 8 months and then drops off the face of the earth for 5, then shows back up again. That's going to be too hard on the child, and if that's a pattern of behavior, if I was anybody other than the parent's attorney in that case, I would probably not be in favor of that, such as the guardian ad litem or special prosecutor. Where the parent has serious substance or alcohol abuse, probably is a very serious factor and reason not to use this, especially when it's been unaddressed, or if it's addressed and it's not successfully addressed. And finally, where the prospective adoptive parent is unwilling to enter such an agreement. We can all sit down and talk to a prospective adoptive parent, but they might say, I don't want to do this. And that's where the inquiry ends, folks, at that point. If they're not willing to enter into such an agreement, you cannot force the agreement with a prospective adoptive parent. Okay, did you know Nebraska has approved these post-adoptive contact and communication agreements? I left out a word, didn't I? Since 1993. The point I'm trying to make here is these things have been statutorily authorized for 19 years in this state. As a state administrative agency, okay, how many people from the department are here? Hands, please. Okay, we won't talk to that side of the room, but HHS is required as a state administrative agency to enact appropriate regulations or administrative policies to implement the laws that apply to them. This law, this 43-162 to 165, clearly applies to the department because it relates only to children in the department's custody. So, again, reasonable minds can differ. My point of view is that they are probably required to enact some kind of a policy to implement the law. Okay, how many people have used these kind of agreements in their cases? Okay, successfully. Okay. Next to John, is it Monica? Is it?
Yeah.
Yeah. How did it work in your case?
Well, as far as I know, it worked well.
Were you the attorney? Who did you represent?
I've had different roles, parents' attorney, guardian ad litem, department attorney.
And in relation to these kind of agreements, when you were a parent's attorney, were you able to sit down with the prospective adoptive parent and talk about what might be possible in terms of visitation?
Sure.
Okay. Who else has had experience with, sir?
I was a guardian ad litem. The department and the caseworker pretty much handled it and worked out the details with the adoptive
Okay.
parent. I just looked at it and approved it.
Was it, in every case that you guys raised your hands, was it a written agreement?
Yes.
Did anybody have something that wasn't in writing?
I think this is probably just as much used as an informal agreement, because there are a number of HHS workers that really, or not just workers, judges, people across the state who aren't on board with it. So often it's a very informal agreement, totally outside of the law, and works very well.
Okay, for the people who raised your hands who have done this, how many of those agreements were presented to the adoption judge and approved as part and parcel of the adoption decree? Okay, all right, well that's good. That's more than I would have thought, because I think over the years, people have struggled with how do we get this done in a proper case. So why aren't we using these agreements in more cases? Could it be resistance by HHS? Problem number one, from my point of view, is a failure of HHS policy to implement the law. You have to have a policy that implements or shows people how this is going to happen. What do the policies say? And these are in your handouts. 390 Nebraska Administrative Code 6002 Openness is the policy that purports to address this issue. Openness will be based on the child's best interest, but here's the kicker, folks. Details of the child's degree of openness is only determined after the child is free for adoption, although you can assess earlier. The department will have input into the agreement between the prospective adoptive parent and the birth parent of a prospective adoptee. The statutory reference, this is not me writing this, but on the bottom, the statutory reference is part and parcel of that administrative policy, and those statutes have nothing to do with 43, 162, 165. Over the years since 1995. Since this law was passed, there have been several additions or several revisions of HHS policy, this 390 NAC, and they constantly refer to 138 to 141 and 146. The problem with this is not only that the statutes cited don't relate to 43, 162, and 165, but if you cannot determine the details of this degree until, the degree of details of the adoption agreement until after the child is free for adoption, what does that mean?
No, it means the parent has no capacity to contract with that entity.
Yeah, you're no longer the parent,
Not the parent.
okay? But it says, see the adoption guidebook. So when we turn to the adoption guidebook, what does that say? It's kind of a mirror image of what we just looked at with the policy, and it goes, it's almost verbatim, it's the same thing. So the policy, first of all, is supported by statutes that don't relate to the continuing contact and communication agreement statutes, and number two, it's predicated on the notion that you can't do this agreement till after the child is free for adoption. So if the child doesn't become free for adoption till after relinquishment, but the agreement has to be signed prior to the relinquishment, do the policies really implement the contact and communication statutes if you don't determine any of this until after the child is free for adoption? Have I lost anybody here yet? Yes? All right, good. So if you're not the parent, if you have relinquished your parental rights, the department has accepted it, and John, correct me if I'm wrong, John Baker in the back who's looking down. The minute that the department accepts that, that pretty much extinguishes the parent's rights. You don't then have any legal stature or status to negotiate or enter into a contract with the prospective adoptive parent. The second argument that I have heard raised and attorneys have heard raised over the years by the department is, quote, we cannot promise a specific placement for any child. That's absolutely true. They can't, because if on Monday they say we will place this child with Ben Gray, and by Friday Ben dies or Ben is addicted to meth, then their hands can't be tied that way. And that is, from my point of view, that is a correct thing. But here's the answer to that. HHS isn't promising anything. HHS does not sign this agreement for continued contact and communication. They're not a signatory to it. Consequently, they cannot be held enforceable for any promise there. Problem 3, this is a little tougher. Quote, a conditional relinquishment is not valid. Okay. In a case, Nebraska case, a properly executed relinquishment cannot be revoked unless it was induced by threats, coercion, fraud, or duress. Okay, this is the case, and it's an old case that I think the department continues to rely on, or has relied on, at least in my discussions with attorneys for the department. The case manager in this case told the parents if they would relinquish their parental rights, there was a possibility that a quote-unquote open adoption could be arranged, provided that cooperative adoptive parents could be found. So the parents went ahead and relinquished. Immediately after they signed that relinquishment, the department removed the child's possessions from the parents. They stopped all the visits between the child and parents. The parents got upset. They went to district court and they filed a habeas corpus action. For those of you who are not lawyers, that's a legal action designed to restore or return custody that's wrongfully taken, or the belief is wrongfully taken. The court dismissed the habeas action filed by the parents, but it did grant a restraining order pending an appeal, stopping HHS from arranging for the adoption. The parents argued on appeal, they said coercion. Here's what they argued. They said they were told by the department if their rights were terminated by the court, they'd never see their son again, but if they signed a relinquishment, they could see their son or visit their son. Here's what the Supreme Court held. The parents were coerced into signing the relinquishments based upon HHS's promise that they would be able to continue to see their son after relinquishment, and the little black letter phrasing that came out of that is a relinquishment conditioned upon the retention of some parental rights is invalid. That was McCormick versus State. Okay, so how do we square the McCormick case with these statutes, 43, 162 to 165? McCormick was decided in 1984, 9 years before these contact and communication statutes were enacted. In McCormick, I love this, the case manager made the offer to the parents in the hallway outside the courtroom moments prior to the hearing on termination of parental rights. So you can imagine the desperation of the parents at that point in time. Under the contact and communication statutes, the parent arguably has time to contemplate his or her decision in advance. The decision to relinquish, that is. In McCormick, the department had not identified any adoptive family. Under the contact and communication statutes, they specifically require that the agreement be signed in advance by the prospective adoptive parents. In McCormick, HHS's offer of this open adoption was very vague. No specifics were drawn up. The contact and communication statutes, on the other hand, require that the agreement set forth a specific manner, how this is going to take place, the frequency, the conditions that govern any post-adoptive contact and communication. In McCormick, after the parents relinquished their parental rights, basically they hit a brick wall. They had nowhere to go, so they went to district court. And that was after HHS signified to them it really was not going to honor that agreement, that verbal agreement made in the hallway moments before the TPR hearing. By contrast, these statutes provide specific legal remedies to address noncompliance by either party to the agreement. Either party can go back to court for enforcement of the agreement. Either the adoptive parent or the bio parent can. Either parent, the prevailing party, can seek an award of attorney's fees. That's, again, discretionary with the court, and that would turn on a lot of factors, such as bad faith, so that's not absolute. The agreement can be modified where it's appropriate. By the way, that's a picture of the boundary waters in Minnesota. Would you like to know? Probably the most important aspect, the statutes address the concern raised by the McCormick case. And this is right in statute. A parent may not revoke a relinquishment of parental rights or a consent to adoption for failure to comply with the terms of the contact and communication agreement. And that's the statute. Okay, so what do you guys do if you think you have a case where contact and communication might be workable or appropriate? The first thing you should do is look at your case. See if your situation fits the requirements of the statute. If you have a parent that's never met the child, forget it. You have a parent who's a raging meth addict and they're not really, addressing that with any measure of regulation, I would say forget it. Start talking with others about it who are on the case. Talk to the case manager or the permanency specialist. Talk to the guardian ad litem. Get some feeling for whether or not that's appropriate. Now, this is assuming you represent the parent. I have had cases where the guardian ad litem has initiated this discussion and felt that it was very much in the child's best interest to start looking down that road. Get the guardian ad litem on board. Make contact with the prospective adoptive parents to explore their willingness. If the answer to that question is no, or hell no, I would say it doesn't go any further. Arrange a meeting between your client and the prospective adoptive parents if they're willing to sit down and talk about this. And generally, and I would say in almost all of these cases, you don't get to this point unless there already is some degree of a salutary relationship between the foster parent and the bio parent, or the prospective adoptive parent. When these things happen and they work, it generally presumes you have a prospective adoptive parent / foster parent who has a fairly positive view of the parent, notwithstanding their faults.
Yeah, I've mediated where you have just the parent or parents and the prospective adoptive parent or parents and the mediated person. They work it out with a neutral facilitator, and the department isn't necessarily the go-to.
Well, they shouldn't.
And that's been successful. And they come up with what the specific term.
We'll talk more about that when we're almost done with this at the question and answer. But the department should not be, and I think the department people will agree with me, they don't want to be part and parcel in the middle of mediating or negotiating the terms, but they do have the right of input after the agreement is formed. Write the agreement. That's assuming you're the attorney. The only signers to this agreement are the bio parent, the prospective adoptive parents. HHS does not sign this agreement. The guardian ad litem does not sign. goes without saying, the prosecutor does not sign, nobody else signs except those two parties. However, once you have an agreement, and this is how I've done it in some cases I've had, I think it's just basic courtesy. And it's also, I think, in your best interest to do it this way. So once you have a signed agreement, present it to HHS and the guardian ad litem. Let them review it. Get their input early. Do you have to do that? No. Is it smart to do that? I think so. Because you're going to find out early on what the roadblocks may be, if there are going to be roadblocks.
Chris, should you do it before you sign it? Like have the two parties created and then
You could.
send it out? Or-
Yeah, I suppose you could. I guess there's no magic to that, but you don't have to do it at all. But the chance you take if you don't do that is you walk into the adoption court, and for the first time, maybe an hour before the hearing, the GAL has read this agreement and department, and maybe they have legitimate basis and reason to object to something in that agreement, and then you're back to square one if the court doesn't approve it. Then you'd have to seek, and I don't know if you'd get it, some kind of a continuance maybe on the adoption to modify that, or the court could modify it. Have the agreement signed before the parent executes the relinquishment. So timing is everything. It's too late if you wait till after to sign the agreement until after relinquishment in terms of the legal capacity piece. Then, once the agreement is signed, it's presented to the adoption court by statute. The statute confers standing on either the prospective adoptive parent by motion to ask that the agreement be presented to the adoption court, or the bio parent can do that. At this point in the hearing, both HHS and the guardian ad litem have the right to give their input to the adoption court on whether they believe the proposed agreement is in the child's best interests. What does the court look at? First, the question is, have the child and birth parents live together for a substantial period of time? The statute says that. Does it require that they have to live together for a substantial period of time? No, it says that's a factor that the court will look at. Obviously, it probably weighs heavily in favor of an agreement where you can demonstrate that there's been some substantial period of time. Does the child exhibit attachment and bonding to the birth parents? Again, a question of fact. The court will also consider the fact that the adoption is a foster parent adoption with the birth parent or parents having relinquished the child due to an inability to provide the child with adequate parenting. Okay, after the court looks at everything, if it finds the agreement to be in the child's best interest, it approves it, it becomes part of the adoption decree, or at least in conjunction with it. It becomes a binding legal agreement between the birth parent and the adoptive parents. But what kind of problems? What if problems develop after the agreement is approved? Who's had problems? What?
Boy, one case I can think of, we signed the agreement and the prospective adoptive parent, before we got to after relinquishment, before adoption, they no longer wanted to adopt these kids because they had serious medical issues. We found a subsequent placement. Parents had already relinquished parental rights, and they were with a different adoptive parent.
That's happened in Douglas County as well, but for different reasons. What other problems?
Just had a biological parent called, was raised now with the adoptive parent down the road, saying they wanted more time, or they disagreed with the interpretation of the document, but it was very clear and straightforward. So it didn't result in anything, but it did cause some grief for the adoptive parent.
Okay.
We got a call in our local mediation center from a parent who had relinquished, and the agreement was being honored.
Wasn't being honored.
Unfortunately, the biological parents wouldn't agree to mediate, so there was nothing.
The biological parents wouldn't agree to mediate?
Well,
Or
no,
the
I'm
adopted?
sorry, the adopted parents.
Okay, yeah, okay. Those are common problems. Refusal to allow contact. You sometimes have the situation emerge where the child no longer wants to see the parent. You may have a parent acting inappropriately at visits, or either side making negative remarks to the child about the other party or disparaging the other party. Mediation, there's some mediation people here. Mediation, this is their picture. Mediation can be included as a term of the agreement. And I would recommend that's best practice. Build that into your agreement if you can. Now, you're going to have those, maybe the mediation people can help us later with addressing the finances, but very often the parents who come into juvenile court are indigent. When you have an agreement like that, if it has a mediation clause in it, you can do a world of good by getting those parties back to the table. But the first question that comes up is, oh, who's going to pay for this, or how can we pay for it? The adoptive parents say, we're not going to pay for this. So we'll call on Jane later for that. If they can't mediate it or won't mediate it, or they mediate it unsuccessfully, or you just haven't provided for it, the only way then to seek enforcement is back to court. Again, the agreement can be modified, and this is important. It can be modified even to the point of termination. So if you really do have an out-of-control situation, you can go back to court and get that agreement canceled, basically. Again, that's provided by statute. Okay, 6 key points. The legislature intended parents could relinquish with knowledge. It's a binding contract. This applies, however, only to children in HHS custody. The agreement's subject to approval by the adoption court. HHS and the GAL have input, but only at the hearing, although you want to I'd want their opinion before that. The agreement is enforceable in a court of law. It can also be modified. Some things to think about. The fact that the legislature has authorized these agreements really doesn't confer any absolute right on the parents to have such an agreement. It's a discretionary decision on 2 fronts. First, if the prospective adoptive parent says, no, that's it, you're not going to go any further with that agreement, unless prior to relinquishment there's a change in prospective adoptive parents and they're more willing. Even if both parties sign the agreement, even if everybody in the courtroom agrees to it, if the adoption judge does not approve of it for whatever reason, there's no agreement. The adoption judge can also modify it on the spot and change it to what the court thinks is in the best interest of the child. The end. Okay. All right. Now, I assume maybe you have some questions.
Well, I was just gonna ask you, what do you see happening in the private sector, or do you? Are there any open adoptions in private places?
I'm not aware of it, and I mean, that's been,
There certainly isn't any
that's
statute.
certainly a thing to think about legislatively. Yes?
I'm Executive Director of Nebraska Children's Home. Open adoptions are the norm in infant adoptions. And what we're doing is taking that foster care. The piece that wasn't mentioned is the relationship, because legal aspects are one thing, but what we found when we recruit foster parents, we recruit them with the understanding that if a child comes into the home, the chances are the child is working toward reunification, and they're expected to work with the biological parents to achieve that reunification. But we also make it very clear that if that reunification isn't possible, we want them to be willing to consider adopting a child. And we know that the majority of children adopted out of foster care are adopted by their foster parents. And of all the children we have in our program, we have over 100 kids every day. Every child that's free for adoption, the home that they're placed in is going to adopt them. We begin that work with recruitment, and then we train foster parents that their job is to work across the family lines, because we believe that those connections with biological parents are so important. Does it work every single time? Of course not, but we have had huge success with that, and I really think there's receptivity. We've worked with mediation centers starting. My goal would be that at some point, I think termination of parental rights is, my background as a therapist and working with the parents, that's a failure. And sometimes people who are at that point are going to feel more in control, more worthwhile if they can say, I want my child to stay with his family. It's a family the child's in a family they know. And we don't make any promises. The relationship builds between the biological parents and the adopted family, and at that point, probably if we would step out of the picture, it wouldn't make any difference, because the relationship is there. The adopted families are educated to understand how important that connection is, and I really see that's in the private sector. I think that is the way it's gonna go.
So the children with whom you're working are not state wards, they're not
They're
any,
all, they're state boards.
Well-
Well, we have infant adoption, there are two, we learned this through our infant adoption program, where if people come in saying they want to adopt, and it's just a foreign notion that they're gonna have any contact with the biological family. If you begin with the educational process very early on, people, and have others present at we have at our foster parent trainings, foster parents and biological parents coming in and talking about how they work together to reunify the child, and also those situations where there's been a termination of parental rights and the adoptive parents and the biological parents are working together still, but we've never, to my knowledge, I'm not sure we've ever had one where there's been a legal agreement. And of course, it's not binding with infant adoption, it's just based on good faith on parties.
well then these agreements do apply to all of your adoptions that are relating to children in state custody, because,
That applies.
but there's nothing within the statute that I found, and folks correct me if I'm wrong, that applies to private adoptions, to create a written legally enforceable agreement.
Right, but we do a significant number
Right.
of
You do it informally.
adoptions out of foster care. I mean, we have them in our homes, and we just, I think it's important that statute be there. I'm just saying, it's not necessarily a legal issue, and you can have everything in place as people have talked about legally, but if adoptive parents back out, and what we try to do is make sure that adoptive parents understand the importance to the child. Most people want to do what's best for the child if they're educated.
Right. In fairness to the department, unless their forms have changed, their typical foster parent agreement does require, at least in the recitals, that they will work with the court-ordered permanency objective, which in most cases is reunification unless there's something different, and that they will positively support visits between the parent and the child, and that they will also, what's the third thing? Oh, well. That they will not disparage the parent or the child.
It really doesn't interfere. The foster parents are working actively toward reunification. At some point, the biological family has decided, this child is really going to be better off than this family. I can play a role, and they do. I'm not disagreeing with you. I'm just saying there's a whole different approach to this, and we contract with the state. These children are state boards.
Well, the greatest protection probably, though, for a relinquishing parent with a child who's in state custody is through these statutes, just because of the enforceability provision. I want to let you know that I've spoken with Margaret Bitz, who is a very wonderful person. She works for the department. She's a unit administrator, and she's head of the policy making end of this. And we talked about this issue, and what she said to me was that on this 390 NAC, the handout that you've got, we kind of went through what the problem was, that it's kind of the catch-22. If you have to relinquish first before you can sign the agreement, you don't have standing as a parent legally, and then where are you at? She is indicating that from her point of view, that the policies are likely to get smaller. The official regulations, they're in the process of doing a lot of revisions. They're going to look at this, but the adoption guidebook is going to get a lot fatter, and that the guidebook will actually contain the hands-on, how to do it, the nuts and bolts implementation piece for workers, but that the policy part might get smaller. And one of the things she said that I thought was interesting was, if it's in statute, whether it's state or federal statute, we probably don't need a policy to implement it, because we're already required to do that by law. We have to do it because the law says so. So watch for some changes that may be coming through the department. The other thing is, I spoke with another person who works for the department extensively in adoptions. Said, how would you handle this if your case manager comes back to you and says, this is what's being asked for in this case, and we're on board? She said, the most we might do is give the attorney for the bio parent the contact information for the foster parent, assuming they don't already have it. But she said, we wouldn't even make a room available for them to meet, because we don't want to be in the middle of this to somehow signify that we're endorsing this to the extent that it could come back on us for a legal obligation or for enforceability. And I think that's a correct position. But she's saying, yeah, it's great. If people want to do this and if they work it out, you know, let them do it. So, any other questions? In the back?
Just from the standpoint of a judge, a couple of questions or observations on the issue as to when not to do this, when you can't do this. The first would be when the adoptive parent just says no or hell no. I would hope that somebody in the system, whether it's the department, is fully explaining to the adoptive parent that there are some upsides to this in terms of if they have the child placed in with them, they run the risk of having a bad prosecutor lose the case. They run the risk of having almost always cases are appealed if there's a termination, and those can take time. So there's also a time factor for them to consider in terms of if they want, especially for their kids and older kids, who I think get closure when the case is over, and that isn't going to happen in my experience until the appeals. But those are some factors that adoptive parents have to consider before they just say hell no.
Right.
And I hope that somebody is explaining to the adoptive parents some of the factors that need to be considered on their decision.
Excuse me, Judge, go ahead.
And number two, and then you can, and I hate to pick on the person sitting next to me who mentioned this, but you agreed with it too, and said that one of the time not to do an adoption or an agreement is when it's a quid pro quo. And my experience from the bench is they're almost always quid pro quo. They're almost always an inducement to the parents to relinquish, to avoid the risks that I just mentioned of a lost case or a judge making a bad decision. I won't just blame prosecutors. A judge can make a bad decision, and there can be a reversal and a remand for a new trial a year after the first trial. So they're almost always quid pro quo in my experience.
Well, I think, and that's probably going to be something like the appellate courts are going to
And
construe.
I know it runs
but,
the risk
yeah.
of the issue of is it fraud, is it inducement?
Right.
But I'm telling you, they're almost all, the ones I see are almost all on that basis.
Another thing parents or foster parents should be educated about is not only the points the judge raised in terms of the likeliness of an appeal and the length of it, but in an appropriate case where there's a positive relationship between parent and child, you'll have some of the best psychologists tell you that years down the road that child's going to say, where's my dad, where's my mom, and there's the risk of greater behavioral problems than you already have. If you can modulate that somehow through continued contact, that may be a wise thing to consider. I want to ask the mediation people this. How would you handle this if we have an agreement for continued contact and communication, there's a problem that develops later, say the foster parent, for example, or adoptive parent says, no, I don't want to do this anymore, and there's a mediation clause and they couldn't pay, how could they go about seeking mediation? Or do you have any suggestions for?
The 6 centers technically accept money from the Office of Dispute Resolution, which says we won't turn.
Can you say that for everybody to hear?
That we won't turn away cases based on people's ability to pay.
Okay.
So if somebody would need a mediation and have no ability to pay, then we would mediate.
Okay. And we also, Chris, we receive funding to help support that, things like the Commission for Public Advocacy, and there are funds that we can tap into, and I don't think a center's ever turned anyone away.
I would just say if you're going to do these, put that mediation clause in every one of them. Both ladies from the mediation center are saying that there is funding. They will not turn people away, who don't have the financial resources to pay for a mediation, and hopefully with much of the talent we have in the state for mediation, some of this can be resolved for the child's best interest. Any other question? Yes.
I represent parents often in these cases and have been the instigator of communication or contact agreements on behalf of relinquishing parents. And I have come to include in the agreement a paragraph that identifies the guardian ad litem in the juvenile court case and the case number, and invite the guardian ad litem to sign on to the agreement you indicated in your presentation. You don't have guardian ad litem
Right.
sign on.
Right.
I, as a parent's attorney, I want them to do that because I want to give the adopting court, the judge in the adoption case, the indication that the guardian ad litem is in agreement, that this contact is in the best interest of the child. And so I'm curious as to why you say don't have them sign. This isn't, it doesn't, I'm not intending to make them a party to the agreement, only to indicate their belief that this is in the best interest of the child.
How do you, Scott, how do you put that language? I mean, do you say reviewed as to form, or?
Yes, I say that identify the guardian ad litem by name in the juvenile court case and the case number, and that the guardian ad litem, if they choose to sign this, is indicating their approval or belief that this is in the best interest of the child. And that's essentially the language. And then I put a signature line on
For
the-
them. I wouldn't sign it if I was the guardian ad litem for the very reason that when or if things go afoul, I'm going to be somehow brought in as a named party in some enforcement. And I know what you're saying, you're trying to dispel that. And maybe with appropriate and sufficient legal language you can say, by signing this I am not making myself a party to the agreement. But the statutes clearly say, 162 to 165 clearly say that the guardian ad litem has input, the right of input with the adoption court, and if there isn't a guardian ad litem, one is to be appointed. So your guardian ad litem from the juvenile court, assuming the juvenile court will handle the adoption because the child's already under the jurisdiction, and under 43-247, I think 10, the court has jurisdiction to do that adoption. You've got everybody right there. If you're moving into probate court, though, and you have a different issue, and I understand what you're saying, but I probably wouldn't sign it. Just a second. Scott?
As a guardian ad litem, you wouldn't.
No.
But would it, as a parent attorney, would you want the guardian
Oh,
ad
I'd love
litem
it.
on?
Yeah. Just in the back.
What's the benefit to having them be legally binding?
What is the benefit to have the agreement be legally binding?
Yeah, as compared to just an informal agreement between the adoptive parent.
Well, the informal, I mean, all agreements can go away, right? But the benefit of this is that the Nebraska legislature has provided a process for enforcement of the agreement. It is legally binding, meaning that if the foster parent changes his or her mind, the adopting parent, the bio parent can seek enforcement, can have that agreement enforced in court, and can also seek an award of attorney's fees if, again, it's a discretionary decision, and the court would probably engage in a process of assessing clean hands and wrongdoing and all of that. The informal agreement, the verbal agreement is nice, but as everybody knows, that can change tomorrow, and if it does, there's no method or mechanism for enforcement of that.
I think that's why the adoptive parents like the informal agreement better.
Oh, I'm sure it is. Yeah.
And that's why they agree to do it.
We're back.
If the adoptive parents are no longer in agreements or do not want to facilitate the contact, and the bio parents want to take it back to court, do they go back to juvenile court,
Ha.
or would they be eligible for a court-appointed attorney?
You caught the problem. And I think it's a serious legislative problem that needs to be addressed. I mean, it can be addressed very simply. I believe those statutes say that it's enforceable by civil action. Well, most attorneys, I think that means going to district court. How many parents in juvenile court, particularly the indigent ones, can afford to get an attorney and go to district court? And if they do it pro se, how are they going to know how to do it? That statute needs to be changed, I think, from civil action to something like a motion for enforcement before the adoption court, and go back to the same court that did it. Because here you've got Judge Sidwell ordering it in one adoption, and then 2 years later the agreement breaks, there's non-compliance, and the parent wants to go to district court to Judge Smith, who says, I don't know anything about these people, this looks like a problem to me, let's just cancel the agreement. You want to go back, I think, to the adopting court. It makes more sense to me to have the same judge, or at least the same tribunal, that authorized this agreement in the first place be the one that either modifies it or enforces it.
I have a question for you as a parent's attorney. This agreement must be signed before the relationship. So the adoptive parents and the natural parents or birth parents enter into this agreement. It's presented to the court. Guardian ad litem or HHS, we don't know their reasons why, say, Judge, we don't think this is in the best interest. The judge disapproves of the agreement. Relinquishments are already signed.
Right,
The judge goes ahead, grants the adoption.
right,
There is no agreement.
right. There's no agreement and there's no recourse.
No recourse.
That's correct. That's correct.
So wouldn't it be better then to have HHS and your guardian ad litem on the same side at the time the agreement is presented?
Well, and that's why I recommend having that discussion early and often, with the guardian ad litem and with HHS, and you know, do this, find out where they're at and what they're
Even
gonna
if
think.
there's just an approval line on the agreement that says, we approve of this agreement, because that way you at least get HHS, and I'm not saying HHS would ever change their minds about anything. But get their approval on that line before the relinquishments are signed, the same with the guardian ad litem. So that you don't have something come up that once that agreement's signed, the relinquishments are signed, and then they show up in court and say, Judge, not in the best interest of the child, and the judge doesn't approve it, no recourse, everyone's done.
Yeah, I see where you're coming from with the want or the desire to have the guardian ad litem and HHS sign. HHS is not gonna sign that agreement, correct, Mr. Baker?
Right.
Ever, I don't think. And if you can get the GAL to do it, okay, I understand that, but I think the risk here is that some creative attorney in an action for enforcement is gonna try and bring in the whole team, you know, and it may be dismissed
But
out.
doesn't that get you right back to it just seems like it's a coercion on the part of the parent, you know, they were told, we can get into this agreement, you know, and this is agreement between the adopted parent and the parent, and it's outside of the province of the court.
Right. The HHS, when they sit down and they accept a relinquishment, the people who do this, help me out here, but they typically have, in their adoption team, they have a questionnaire and they go through these questions with the parents. And I think one of the questions is, have any promises been made to you incidental to this relinquishment? And the answer they need is no, or they have to stop the process. Probably there's a need for revision of that makes it clear that HHS is not making any promises, and any other promises made on the side do not give rise. It's almost like a legal advisory, which the attorney should be doing for the parent, that says, you understand that, you know, if this thing goes south, you don't get to revoke your relinquishment or cancel the adoption. You know, at the end of the day, I think it's not a perfect creation, but it's better than not having any kind of an agreement. And the fact that you have an agreement maybe psychologically influences adoptive parents to say, gee, I signed that, you know, maybe I do need to act in good faith. Most parents give the magic answer, am I right, when they're going through that questionnaire at relinquishment. Why are you relinquishing? Because I believe it's in the best interest of my child. All right. 1 minute, okay.
I'm an adoptive parent and a foster parent and adoptive parent trainer, and I would sign this one. I believe.
You would or would not?
I believe.
All right.
The way this one's written, I believe in kids maintaining contact with their birth parent. I have adopted agreements with all of mine, but on mine it always says that at the bottom it's like what I feel is in the best interest of the child, because there are times where the child's emotional stability may not be relevant.
Right. That could be written in, or you may not sign the agreement. It's one of the two. I mean, something like that can be written in, that the times and terms of agreement can be extended or reduced as per, you know, the agreement of the partner. Well, this is just a sample, folks, and this is not, what is in the handout is a sample, just an idea to get you thinking, because I can't find anywhere in the world a proposed contract for continued contact and communication that Nebraska has officially endorsed. So build on it, change it. Somebody else had one more question real quick.
Well, I was just gonna say that your agreement doesn't have that clause in there about mediation.
No.
And you say add that, you
Add
recommend
it.
you add that.
I screwed up, but that was written before mediation, okay.
My thing, when people are talking about kind of plugging everything into one contract, so it's, you know, everybody's protected. I think when you're talking about the legal document, what's missing is there's gotta be a relationship between these two parties.
Yeah, and
And if
that's.
that's not there, then this isn't gonna work out.
Right, that's right, and that's why I'm saying in most of these cases, it presumes you already have a positive report. Lynette, quickly.
Now, I was just gonna say, your GAL should come to that adoption hearing, if you think they might not come, subpoena them in. They'll say, write a record and hear an agreement. But I've done a gazillion GAL cases in my career, and I was never signed an adoption agreement. You would not find me signing an adoption agreement. Because it's just, you know, I'm gonna get a call 10 years later, I mean, it's needed to report, to be a testimony in case I don't remember, you know, so I would sign it. But I know that, on record.
Okay, thank you very much.
Thank you.